the 2019 Fall Business Meeting Legal Update. Also, this is the very last day of summer. I know, but I think the heat humidity kind of reminds us that it's going to go on past today, so, but, you know, last day of summer. So I have a very busy agenda to talk to you about today, but before I start talking about what we're doing today, I want to remind everybody that recently NYSAR has merged the legal hotline and the tech line together under one phone number. So now when you call the legal hotline at 518-436-9727, you'll get a choice of press 1 for legal, press 2 for the tech line to try to promote the use of the tech line to members because it's a very valuable service. We want to, again, have more members utilize it so that it's something we can keep going forward with rather than have something where there's not that much of a member interest and we have to drop the program. Please keep in mind that, again, when you call the legal hotline now, you get a choice of the hotline or the tech line. I left my topics up long enough for you to see them. Obviously, I have a very, very full agenda. I think the first 2 topics will be the most controversial, at least that's been my experience so far. I apologize to those of you who may have seen me do one of these presentations in the past few months. A little bit may have changed, but it's pretty much almost the same thing. But again, the general membership as a whole hasn't been exposed to these topics yet. So let's talk about the new rental laws. Now you know how I feel. All right. So the new rental laws were effective either June or July 14th. Either way, they're effective now. That's all that matters to us. There's multiple facets to the legislation as far as the areas of law that it covers: general obligation law, real property actions and proceedings law, otherwise known as the RP-APPLE. Most of the new laws are outside the scope of licensure, which means that matters relating to the rent control, matters relating to how evictions are done, that's not something that's within the scope of licensure. So as a licensee, you don't have to know that information. That's something landlords need to know. So what I'm talking about today is limited in scope to what applies to you as a licensee. There are 5 issues that are within the scope of your licensure, pursuant to the DOS guidance that we all got about a week ago. If the law refers to a landlord, it's also referring to a licensee acting on behalf of the landlord. So DOS has expanded liability to licensees. If they're acting contrary to the law, then DOS can take discipline against you for doing so. And I'll explain the limitations of the DOS memo shortly. Very shortly. So the guidance letter from DOS was drafted to show licensees acting as a landlord's agent that you may be disciplined by DOS for certain acts. This is strictly DOS saying we can discipline you under the license law. DOS's interpretation on the guidelines should not be relied upon to ensure compliance with the law. The guidance letter was merely something giving examples to you, showing you under which circumstances DOS could bring discipline against you. DOS is not the entity charged with interpreting the law and its applicability, which is why I'm telling you this. DOS is only, again, looking at how they can go after you in a disciplinary action if you violate certain provisions of the new rental laws. Division of Homes and Community Renewal is a proper entity, as well as the Attorney General. So they would be the entities that bring action against you if you violated the law, compared to DOS disciplining you for violating either misleading, incompetency, untrustworthy, those types of general overarching obligations you have as a licensee with the department. So I said license activities, section 440, paragraph 1 of the real property law lists what a license activity is, right? Lists for sale, sales at auction, otherwise exchanges, buys or rents, or attempts to negotiate a sale at auction, or lease, or collects or offers to collect rent. That's considered to be a licensed activity. Very limited in scope. Like I mentioned before, if a broker undertakes additional responsibility or liability outside the scope of licensure on behalf of the landlord, the broker should retain their own attorney for legal opinions on such matters. NYSAR does not and will not provide information on matters outside of the scope of licensure. So obviously, we've gotten a lot of phone calls lately about the new rental laws. And Liz can attest to this as well. Probably half the calls are licensees calling, asking a legal question on behalf of the landlord that the landlord should be going to their attorney for. It's not something you as a licensee can disseminate to the landlord because that'd be providing a legal opinion. So much of this is outside of the scope, like I mentioned before. So what's within the scope? Deposits, advances, fees, credit background checks, and receipts for rent. So many people were confused when the law first came out about whether or not it was applicable to all rentals or just to rentals that had more than 6 units. So I'm showing you a red line version of the previous law versus the new law that was passed. If you see the old law, and I have it in red, it applies to written leases and residential premises containing 6 or more dwelling units. The new law eliminates all of that language, and it says this section shall apply to all dwelling units in residential premises. Every rental. That's what it means. They don't change the language to make something more vague. They change the language to make it applicable to everything. So if someone tells you it doesn't apply to me because it's under 6, it doesn't make a difference. It's all rentals. Security deposits under general obligations law, the GOL stands for. No deposit or advance shall exceed the amount of 1 month's rent under such contract. That seems pretty straightforward. However, other types of deposits were not addressed in the law. The entire legal community is shrugging their shoulders. So as an attorney, we have the New York State Bar Association. They have a bulletin board that attorneys go to and they discuss issues, and these are one of the things that they discussed. And it's amazing seeing all these attorneys just passing on, because attorneys like to hear themselves talk, like to write things down. They were all passing on giving opinions because they can't give an opinion because it's so nebulous. So we don't know whether or not additional deposits would be permitted under the law. Now, I can't tell you to take them. I can't tell you not to take them. But if nobody knows whether they're permitted or not, it's going to take either a change in legislation or litigation to determine whether or not they're permissible. That's all I have for you. I wish I could give you more guidance. I can't. I really can't. Now, you have to understand, as counsel to NYSAR, I have to give you information based on the lowest common denominator of membership. You may hire your own personal attorney to represent your brokerage, who may give you opinion and tell you, you may do this, you may not do this. But you're paying them to do that risk assessment. I can't do a risk assessment for 55,000 members. It just doesn't work. So if you need further guidance on whether or not something is permissible, you should retain your own counsel to provide that personal legal opinion to you or your brokerage. And that goes true with everything else I'll show you that we're going to shrug our shoulders for, okay? So return of deposits under general obligations law. Within 14 days after the tenant has vacated the premises, the landlord shall provide the tenant with an itemized statement indicating the basis for the amount that they're keeping and shall return any remaining portion within that 14-day period. If you're a licensee, you're holding security deposits for the landlord, you need to make sure the landlord complies. DOS guidance letter, again, an agent who is working for a landlord who is holding a security deposit is required to comply with this section. That's very clear. If a landlord doesn't comply with the 14-day requirement, the licensee must return the deposit to the tenant as the landlord forfeited any right to retain any portion of the deposit. I think that's very clear as well, okay? Let's talk about advances of rent. What's an advance of rent? No deposit or advance shall exceed the amount of 1 month's rent under such contract. So deposits or advances. You can no longer ask for first month's and last month's. You can get first month's, you can get the deposit at the onset of the transaction. You can't get last month's anymore. Okay, you just can't. I've had many phone calls with individuals having very entrepreneurial thoughts of how they can get around this. Again, I recommend you hire an attorney if you want to get an opinion on some kind of workaround, but as far as NYSAR is concerned, it's black and white, okay? Any agreement waiving any of these obligations is void. So even if the landlord and tenant agree to waive a provision of the new law, you can't. So landlord said, well, wait a minute, the tenant wants to do this. No, you can't waive the provisions. And I put it in red. Okay. So now we go to the real property law. So we're out of the general obligations law into the real property law under the landlord-tenant section of the real property law. Okay? Again, applications, can't charge application fees, except background checks and credit checks, and that's capped at the cost of 1 month. Now, talking about fees and credit background checks, again, it's applicable to all residential units. So regardless, there's that $20 cap on them total in the aggregate, not 20 per, it's 20 in the aggregate. So again, landlord can't charge any additional fees. This includes application fees. Okay, now here's the part that people, please pay attention. We don't believe that the prohibition on additional fees applies to commissions. The reason why is we feel if it was meant to apply to commissions, they would have included the word commissions within the statute rather than the general term of fee. Now, this would be something that NYSAR would obviously defend if there were a lawsuit saying that you can't collect commissions at the closing of a lease, because that kind of defeats the purpose of our income, right? I mean, we kind of need the money at the end because we're done. For those of you who do rentals, and for those of you who are getting commissions at the time of the lease being signed or the tenant occupying the apartment, call it a commission. Don't call it a fee. Right? You call it a fee, you're risking it. Call it a commission, because that's really what it is. Okay? Refer to it as a commission. We'll take questions at the end. And we're not sure how this applies to co-ops and condos. Who said that? You mean the DOS guidance letter that doesn't interpret the law? That was the DOS guidance letter. That's not accurate. We don't know yet. DOS is not the entity that should be interpreting that, so we just don't know. Pardon me? But DOS is not the entity charged with interpreting that law. And I don't know where they got that information from. It didn't come from the Attorney General or Division of Human Rights, so I don't know where it came from. We don't know, right? Technically, so, the argument for why it applies to co-ops, technically, the board owns the building, right? You buy shares, they give you a proprietary lease. So technically, they are the landlord, but again, we don't know exactly how that's going to play out. We talk about credit and background checks. Again, there's a cap for $20. Many of you have called indicating your concern that there's no company out there that charges $20 for a credit or background check. And what are we supposed to do? If you want to pull the report yourself, either you or the landlord has to make up the difference. If you don't want to make up the difference, the law provides that the tenant can bring their own copy of a credit report, less than 30 days old, and you have to waive the fee. So they have the option to bring their own credit report with them. No, I don't know what would qualify as a credit report versus what you normally pull. No, we're not sure whether or not you can tell them, go to this website and fill out a report and they have to pay for it. Those might be questions that we can ask Erin Sapkowski, who's coming to the Fair Housing meeting. She's from the Division of Human Rights in New York State. She'll be talking about these matters. So she might be the individual who may be able to give you an answer for this, or she may not. But we do have someone coming in at least to speak about this as well. I don't know, Barbara. I'm telling everybody it's $20, period. That's what I'm telling everybody. I know, but we don't know. I mean, you read the law. I can't make sense of it, so. Yeah. Again, credit background checks, we talked about it. They can charge a fee, $20 the max for the fee, but you can make them go and get it themselves and bring it with them. That's an option you have. Whether or not you trust the reliability of the entity they use to pull that report, again, that's something we have to vet out, and hopefully it's going to work itself out either legislatively or through litigation. Again, we don't know if a landlord can require certain, like, I only want you to get your report done through TransUnion. Here's the website. We don't know if landlords can dictate which credit report that the tenant can use if they want to do it themselves. Receipt for rents. Collecting rents is a licensed activity. So upon the receipt of rent for the premises in the form of cash or any other payment, the landlord or the agent working for the landlord has to give them a receipt containing the date, the amount they gave, the identity of the property, what period was it, right, September 2019, and signature and title of the person receiving the rent, right, Anthony Gatto, real estate broker, property manager. That's what you would have to do. A tenant may demand in writing a receipt for a personal check, right, because usually the check itself is the receipt, for those of you who get checks back or images of your check back. But again, if there's a request, then the landlord must comply and provide a written receipt to the tenant. So let's look at the old law versus the new law. They talk about the tenant requiring the landlord provide a receipt. They changed the law a little bit to include any agent of the lessor, which is us, right? Again, the request shall remain in effect for the duration of the lease. So in the event a tenant asks you for a receipt for personal checks, they don't have to ask you every month. They ask you once, and that stays for the entire length of the lease. As a course of habit, if I were a landlord, every personal check I get, I'd send a receipt out, because then you're not waiting for the exception to happen and forget it, right? Put that policy in place. It's 50 cents for a stamp or email, whatever you want to do, but that way there, you're going to make sure all your bases are covered. Again, more payments and receipts for the lease. To give the landlord, the receipt has to be there within 15 days of the lessor or agent's receipt of the rent payment, if it's transmitted in different ways. So if you read 238 and 235 together, 235E talks about late payment of rent, and if the landlord does not receive that late rent payment within 5 days of the lease, then you send to the tenant by certified mail a written notice stating the failure to receive the rent payment. Failure to do so by the licensees may be used as a defense by the lessee if there's an eviction proceeding. So if you want to make sure you're keeping your right to eviction ripe, you want to make sure that letter goes out or the landlord has you sent those letters out. If you're a property manager, consider making this part of your policy that your landlord agrees to. Okay, being proactive is very good as far as evictions are concerned. And believe me, with the current political climate in New York State today, considering tenants' rights, I believe that any court will find any reason to kick out a landlord's lawsuit if they can find one little small thing the landlord did wrong. Okay? Late fees, again, read this in conjunction with the other one, but you can't make any demand for any payment for a late fee unless it's been within 5 days of the date it was due. And then the charge can't be higher than $50 or 5%, whatever is less. So they're telling us how much we can charge for late fees now. Obviously, with some properties, this doesn't make a lot of sense, but they didn't take a lot of that into consideration when they passed the new law. And just so those of you know, when the law was passed, we had zero notice, and we had almost no opportunity to make any input at all. And if we did, it wasn't paid attention to. This came through like a steamroller, and it came through and it was passed immediately, and there was almost no time to comment, which is why I'm up here telling you there's a lot of things that we just don't know. All right? So how do we find out more? Legislative Policy Forum, Tuesday at 12:30, Mohawk Room. Nick Mastro-Simone from Harris Beach, he authored the NYSAR documents you got, the 13 things you need to know in the memo. So he will be here at Legislative Policy Forum to discuss those matters. Mike Kelly will also be there to talk about it as well. Nick's not going to tell you anything I didn't already tell you. He doesn't have any secret answers that he's going to say, well, I think that you can do this. He and I had discussions, and it's amusing when you have attorneys on the phone and neither of them can give you an answer because they don't know what the answer is. So we just kind of sit there in awkward silence until one of us says something. But he and I are on the same page as far as our interpretations are concerned. Well, now time for questions too. Go ahead, Mike. Oh, did I mess that up? Oh, that's ledge steering is 12:30. Okay. 11 a.m., not 12:30. Questions? We have people with microphones running around, so please raise your hand, they'll come to you.
Good morning, Pam Jones, Hudson Gateway. With respect to the advanced deposits, does that, let me do it this way. Does that provision of the general obligations law now prevent a landlord and a tenant from agreeing that the tenant will make an advance payment of rent within 6 months or 3 months?
Okay, I know what your question is, sure. Can a landlord and tenant agree to have a different term on a lease, therefore the tenant can pay, for instance, the lease is quarterly instead of monthly or something like that, or they can pay for the rent up front for an entire year? We don't know, and at this point I'm going to tell you I don't think so. But we just don't know.
Follow up, with respect to the limitation on the imposition of fees for credit check and background check, is that an aggregate? Can it be $20 for the credit and $20 for
No, it's $20, period.
$20?
Period.
Thank you. Hi.
Yep.
Sorry. My question has to do, you mentioned about the lady that's coming tomorrow for the fair housing meeting. Have we, no, fair housing is Monday. Tuesday is other policy.
Yeah, Tuesday's this, yeah.
Erin, okay, fine.
I got the
Tuesday.
two things that, sorry, rent, the lawful source of income is coming next in my presentation. I got the two mixed up.
All right, cool. Have you actually spoken with Erin before to ask her these questions so that we're not bum rushing her on Tuesday?
Erin received a copy of all the questions I have for DHR as well as what I believe to be the answers to them, so she has been supplied with that previously.
Okay, so she's been, from back in June, I'm assuming she was supplied with the questions and stuff like that?
About 3 or 4 weeks ago.
Okay, because it's just a lot. She's going to get bum rushed on Tuesday. It's just a lot.
I know, but you know what? She's going to have answers just like I am. We don't know. Honestly. So, but speaking of that, recent decision of interest. I changed things up. Topic, court case, so go ahead.
Two questions, Anthony. One on a credit report itself. The credit report that is provided by the tenant is not a complete report. How are we going to deal with that one?
I said before, I don't know.
All right.
I don't know.
The second thing is that on a credit report, we have been told in the past, in order to be not discriminatory, your report has to be identical and exactly the same across the board. Now, each tenant can supply us with a report, and that report would be contrary to other reports in terms of employment, court proceeding, and all other things. So just taking a tenant's report is not an answer. The landlord cannot make a decision on one tenant on one base and against another tenant on another report. So that is already a contradiction based on their recommendation.
It's not a recommendation, it's a law. It's not a recommendation. If they come to you with a credit report, you have to take it.
I understand. I used it the wrong term. The second thing is, as part of a report, a landlord has to decide whether it is quality tenant or not. And as part of that evaluation, they use the past record payment against a court proceeding. And now, they are being
use
told
that anymore.
court proceeding cannot be even used.
No, it can't.
So as a businessman, on what basis you're not questioning the legal source of the income. You're not questioning the character of a tenant. So you open up the door and invite everyone to your building? That's my question.
The law is what the law is. I mean, there's nothing, it is what it is. I can't provide any other guidance. That's it.
Anthony, Don Radke, Syracuse. Is there any issue with proper information for the receipt to be emailed rather than mailed?
I just believe you have to deliver a receipt so long as you know that that's the individual's email address. I don't see why that would be not permitted.
Okay, thanks.
Anthony, my question is very simple. I need some clarification in fee and commission. You said use the word commission and not fee, but my understanding of fee is any service rendered you get paid, and that's a fee. Also, any service rendered you get paid through a commission, it's a commission. So what is the difference, and why will we get in trouble for using commission instead of fee?
Because the law uses the word fee, it doesn't use the word commission. So if you want to make sure you protect yourself and not raise any red flags, use the term commission rather than fee. That way there, the tenant's not going to say, wait a minute, the law says the landlord can't collect any fees. Well, don't call it a fee, call it a commission. It's just going to raise less red flags. That's all.
For self-remedy, in the event a tenant leaves unexpectedly, and maybe for a month or a period of time, they've been behind, they vacate the property, what should a landlord do at that point to say
I can't, that's outside the scope of licensure, I can't answer it.
Okay.
Landlord has to retain their own attorney for that.
And then if a tenant approaches a landlord to leave, also self-remedy.
I can't answer that question either.
All right.
Okay, we have to go to the next topic. Here's a good case. E versus W, Appellate Division, 2nd Department from February. E was a consumer looking to purchase property. W was E's buyer's agent. E through W submitted an offer on a property. Simultaneous with E's offer, W negotiated their own offer with the seller. So the buyer's agent, representing the buyer, submitted an offer for the buyer, then, unbeknownst to the buyer, negotiated their own deal with the seller. The agent's offer was the same as their client's offer, but had a larger deposit than their client had. The agent claims that it was merely a backup offer, but the seller accepted the agent's offer over their client's offer. Does anybody see a problem? So the agent testified they were representing the buyer in connection with the attempt to purchase the property. The agent negotiated with the seller to purchase the property for herself. She testified at the deposition that she conveyed an offer from the buyer to purchase the property and also submitted her own offer, which she characterized as a backup offer. But the last time I checked, sellers don't accept backup offers as the primary offer, right? Okay. I just want to make sure my terminology is the same as yours, so we're on the same page. The agent did not disclose to the buyer that she was interested in purchasing the property herself. Didn't disclose that she submitted an offer. The seller accepted the agent's offer on November 25th. The agent notified the buyer that the seller had accepted a different offer, but didn't tell them it was their offer. Right. Is this becoming clearer now? The buyer learned the seller had accepted an offer from the agent when they went to the agent's office over a couple weeks later and found out that the seller and the agent were already in contract. The court makes a very pointed dictum in their opinion where there are divided loyalties, right? There are very much divided loyalties. Not only that, but the broker is acting, or the licensee is acting in their own self-interest to the detriment of their client, right? You're violating every single fiduciary duty. All 6 right down the board, boom, right? Oh, a breach of this duty constitutes fraud for which the broker is answerable in damages. Yes, they are. So obviously, the agent got in some trouble. Not only through the court, but I believe that this was followed up with a DOS complaint as well. So these are probably things you really should not do. And I always recommend to licensees, don't show any interest in houses where you're showing clients those same properties, right? Once you show someone a property, that property is out of the ability for you to purchase it. That's the best practice you can do, okay? Again, don't put your interest above that of your client. We have a hand up in the back.
Is there if the tenant has not specifically requested a rent receipt, is there any burden to send them? Because normally, if you have to go to court, the burden is on the tenant to show that they paid, not for you to show that you gave them a receipt.
You supply a receipt for every single rent that you receive, unless it's by personal check. Then if they ask you, you have to send them one for every personal check they send you.
If they ask.
Only for personal checks.
Only for personal checks.
Otherwise, it's universal.
You gotta be kidding.
Up here next to Scott, Nina.
Hi, in this case, did the court go further and say if it was a broker agent, what would have happened?
No, they did not. But I think it would have been the same conclusion because you need to at least disclose to them, right? You have to be honest and trustworthy with all parties involved. So I think it would have fell under that at least, that overarching obligation that licensees would have. Okay. Who's ready? Right? If you thought the rent control was bad, you ain't seen nothing yet. So again, lawful source of income effective April 12th, otherwise known as now. Lawful source of income is now a protected class in New York State. It's in the same list as age, race, religion, gender identity. Lawful source of income is just another one added after the comma, but it's in the same exact area of law as the other protected classes are. Lawful source of income includes, again, child support, alimony, foster care, Social Security, any form of federal, state, or local public assistance, any type of housing assistance, including but not limited to Section 8. There are many different forms of housing assistance, okay? All different levels of government gives out housing assistance, right? From the smallest village to the largest city. So it's not just one source as far as programs or housing assistance is concerned. So the subdivision itself eliminates or prohibits you from using specific criteria or qualifications for the eligibility unless that property is publicly assisted. Then if the public assistance program requires some type of qualification, you may do so. Normally, these qualifications are to show that the person does not make a lot of money and falls below a certain salary threshold. Unlike the qualifications landlords want, which shows the person's credit score and income and whether or not they would be a viable tenant. All right, so this is for publicly assisted housing. There are some criteria that individuals must meet, and only in those situations may you have some type of criteria or qualifications. Let's wait till the end. If a licensee is involved, there are no exemptions or carve-outs. So the landlord says, I live in this property, it's 2 units or less, it's owner-occupied, I don't want these people living in my home. Your answer is, then you can't work with a licensee and you walk out the door. You can't represent a landlord who's taking the exemption for themselves. It's a personal exemption to them, and they are prohibited from using a licensee, and you are prohibited from representing them if they want to use the exemption. That's it. Okay? We talked about criteria qualifications, issue of full rent being paid versus partial payment. That's one of the things we'll talk about shortly. Landlords say, but I need it. So here's the deal. If a tenant comes to you and they're on a program, and that program pays the entire rent, the landlord cannot run a credit check. The landlord cannot ask for income. No W-2s. They can ask for documentation from the program showing the amount of rent the program will pay. But otherwise, that tenant is qualified because the rent's getting paid. Credit scores have nothing to do with it. How much money they make has nothing to do with it. Whether or not they get a W-2 has nothing to do with it. If some of the rent is being paid by a program and the tenant is responsible for a portion of the rent, if it's a nominal amount, I don't believe the landlord would be justified in running a credit check for someone who has to pay $75, $100 additional a month. If it's more than nominal, and no, I can't tell you what the cutoff is between nominal and not nominal, I believe the landlord could run a credit check to make sure that the tenant can pay the additional rent depending upon the program itself. Again, I can't tell you where that cutoff is. But I think that that's how I'm looking at how the laws will be interpreted. Again, you can't advertise anything that expresses directly or indirectly the desire of the landlord not to have someone who's subject to lawful source of income. Can't say no Section 8, can't say no programs. If you know that a landlord tells you not to present any applications from the tenant receiving Section 8, you tell them it's against the law and you walk away. If the landlord gives you a directive to discriminate against individuals because of lawful source of income, again, you have to walk away. Tell them, I can't do what you want me to do, I need to walk away. Now, if you know the landlord's accepting the applications, but historically, they've never approved a Section 8 tenant to reside there, but they take the applications in anyway. But the net result is, no matter how many applications they take, they've never accepted a tenant subject to a program. I think that would be a good presumption that they are discriminating. Although they're not telling you, I'm not going to take Section 8 tenants, they're just doing it themselves. I think that would be somewhat suspect, and maybe ask yourself whether or not it's worth it liability-wise for you to continue with a landlord that you know is not accepting these individuals as tenants. We got to wait to the end.
We can ask questions?
In the event there's some discriminatory action, again, document what you said to the landlord and what your activities were, so that in case there's a lawsuit somewhere down the road, you can say, well, wait a minute, here's my notes I took when I told Mr. Jones I can no longer represent him because he's no longer taking individuals who have Section 8, right? Document everything. It's not unlawful to ask about income, only to discriminate based on lawful sources of income. You can say, what is your source of income? Right? They can say, here's my W-2, here's my last 3 months pay stubs, here's my letter from, Albany County Division of Social Services Housing Assistance. Right? All of those are acceptable. You just can't ask for things related to employment as a requirement from individuals who are on a program. Just ask for proof of the program. Okay? So here are a number of questions that I posed that NYSAR has sent to the Division of Human Rights. We have supplied them to Erin Sapkowski, who's coming to the Fair Housing meeting as well, so she's aware of these. I will tell you what I think the answer would be, but I don't know for sure. Hopefully Erin can help to clarify some of those matters at the Fair Housing and Cultural Diversity meeting. We talked about this before. Can the landlord require the tenant submit to screening? Again, if the full rent's paid by the program, I would say no. If only part of the rent's paid by the program, I think that nominal value would come into play. So you'd have to take that on a case-by-case basis. Can a landlord or their agent require a minimum credit score? If someone's subject to lawful source of income, the answer is no. For other tenants, yes, they can. But for individuals who are subject to lawful source of income protection, no, they cannot. Can an application ask for income information, employment status, or must it only ask for lawful source of income? I don't think that makes a difference. So long as the only choices aren't, employment salary and nothing else, right? You have to include something there to indicate that they're on a program and this is what they're supposed to get. What kind of proof can you ask for? You can ask for a letter. Now, I was informed that there are some programs that don't issue letters, and they will give you a verbal confirmation over the phone. I don't feel really comfortable with that, but I don't think they're going to give us much of an option, right? If that's what the program does, that's what the program does. If you want to call back the program to verify that's the number you got that they called you from, you can do that. That's fine. But some programs don't give paperwork. Does a landlord have to accept a voucher from a program instead of a cash security deposit? Yes. If the program gives you a voucher instead of a check, the landlord has to accept the voucher. Can a landlord require a new tenant to provide the first month's rent, security deposit, and broker commission at time of occupancy? They can require it, but if the program doesn't permit it, the landlord has to accept the terms of the program. Yes, I know, this is not good, but this is what we're dealing with now in today's climate. So this is what we have to adapt to, okay? This last one's kind of interesting, and I'll explain to you why. If a broker normally charges 1 month's rent as a commission, and a program only offers the broker 50% of 1 month's rent to the broker for a commission, can the broker refuse to work for less than they normally charge, or are they forced to accept a lower amount? Can they ask the tenant to cover the additional 50%? Let's look at this a little bit. Now, New York City's had these laws for years, so we have a little bit of a precedent as far as things are concerned. New York City believes that brokers cannot turn down someone subject to lawful source of income because that's discrimination. Regardless if the program pays you a month or a half a month, you can't turn them down on that basis. I don't agree with that. I think we have a constitutional challenge to this, right? I believe we do. I believe NYSAR would defend this if it came to a lawsuit. We haven't heard of anybody getting in trouble yet for it. I don't know of any upstate programs that limit the amount of commission to a half a month's rent, but I know there are some downstate programs that do that. think Nassau County DSS at one time had that. I don't know if they still do, but these programs are out there. I don't believe you should be forced to work for less money than you normally work for. Okay? We're not like insurance agents where we're regulated as far as how much we can charge. Commissions are negotiable. So what this means is that I can be a tenant who's on Section 8. I'm watching $1 million listings in New York City. I see that agent. I call up and say, I want you to find me a Section 8 property. Here's how much money I have for rent. He can't tell me no. I don't believe that's truthful. I don't believe that would be the fact. I don't see that holding up. I just don't. But we will wait and see. Listen, I can tell you, if they keep passing laws like this, I have no problem with job security. I really don't. Here's a good question. If the program requires an inspection of the premises and the item fails the inspection, but is not a violation of any code, law, rule, or regulation, and is otherwise valid to rent, does the landlord have to repair the premises to the standards of the program inspection? I don't believe they would have to. If they have another ready, willing, and able tenant who's willing to take occupancy of the unit, I don't believe the landlord would have to make those repairs, so long as the repair wouldn't be required by the municipality or the state. Right, so other than so the Section 8 inspection, they flag things that are otherwise legal for the municipality. Right? The landlord would not have to repair that to bring the property up to code. They'd have to repair it to bring it up to Section 8 standards. I think if the landlord has another ready, willing, and able tenant at that time, they don't have to make the repairs. If there's no one else, I think the landlord would have a tough argument as to why they didn't make the repairs for that particular tenant. And no, landlords cannot refuse the inspection from Section 8. Wait till the end. For tenants eligible for a program, regardless of whether the rent is paid in full or not, can landlords inquire as to how tenants will be paying for utilities or other matters? No, they cannot. They cannot say, Pat Riley's on Section 8. I don't believe he can pay the National Grid bill. I want proof that Pat has enough money to pay the National Grid bill. No. Can't do that. Cannot do it. Again, the rent is paid, the tenant is qualified. Period, end of story. Okay? So how do you find out more? Well, Fair Housing, Cultural Diversity, Tuesday morning. Is this time right, Patrick? Did I get this one right? Okay, I just picked on Mike, that's all. Tuesday morning, 8:30 in this room, okay? Please listen. Be nice to Erin. She didn't make the laws, she's just charged with interpreting them. And I think as an association, we want to continue our friendly relationship with the Division of Human Rights for the state of New York, rather than have her sit up here and people start throwing stuff at her and yelling at her for things that she really are beyond her control. So I gave you a brief overview of the kind of things that I address with Erin that I think that our members have as far as questions are concerned. Hopefully she can clarify some of those, and some she may just say, I don't know. It's going to take litigation to determine that. And unfortunately, we have this and we have the rental laws that are both kind of vague and nebulous as far as some of their provisions are concerned. Questions? I think Barbara's the first one I hand up. Yep.
Hi.
Hi.
Concerning Section 8, and I think you may have touched on this within your last few comments. I have a client that owns about 35 apartment houses in Nassau County. Will accept programs, will accept Section 8. Except Section 8 on some of those properties won't accept the building. Okay? When someone calls, we have all these other buildings, and we wait to them. They will accept Section 8 on this building, but we suggest that you call Section 8 first, because it's our understanding they will not accept that building. But if they do, the landlord will accept Section 8.
Sure. Or it's been our experience in the past that Section 8 has turned down something.
And that's okay.
So I think if you give disclosure, right?
Right.
Adequate and thorough disclosure
Right.
without trying to discourage them.
Right.
I don't see that being problematic.
Okay, just wanted to make sure, wanted your opinion. Thank you.
Hi, Heather DeValla, Columbia Green.
I don't know where I'm looking.
Sorry.
Oh, okay,
Yeah, back here. Hi. So I have a question about the law regarding the credit check, about, I guess, gainfully employed individuals as opposed to individuals that are on like welfare. So essentially, the landlords can discriminate against those that are gainfully employed with the credit report, correct? Is that what I'm understanding?
They can set qualifications and criteria under which they will accept tenants, yes. Don't say discriminate.
Okay, but for those that are gainfully employed, but not for those that are on?
Correct, yes.
Okay, cool.
Anthony, Linda Fields, Jefferson Lewis Board of Realtors. What is the history of this law, and do you anticipate it going any further?
So, if you've ever attended any of my legal updates, I told you, lawful source of income is coming to the state of New York, right? It started incrementally, started in the metro area, Nassau, Suffolk, Westchester, town of Hamburg, West Seneca, Syracuse, Erie County, right? They all put it in place before the state did. Things trickle up in New York. That's the origin of it. And again, with our current political climate, you see more and more things are favoring tenants over landlords. This is another one of those bills that just fits into that puzzle. Okay?
Hi, Leah Carroll,
Leah.
Hudson Gateway. In Westchester County, where we've had source of income as a protected class for quite a while, co-ops and condos were carved out. I understand that under the state law, would no longer be a carve-out. However, in the rare instances where co-ops do allow for renting, and a tenant gets to go before a board, which they never get to, and are still declined because of the failure to pass the co-op law, they are never given a reason. So I would argue for the ledge steering folks in the room that the same lawmakers who enacted the source of income legislation should be fully embracing the co-op transparency legislation so that tenants for co-ops and condos would be treated the same under the law.
Yeah. Cheer. Everybody clap. I agree wholeheartedly, just so you know. Yes.
Hi, Marcia Clark, Brooklyn Board. My question is regard to the Section 8 and the landlords. If a Section 8 applicant sees an apartment, the landlord, am I correct in stating that the landlord has to take that apartment out of anyone else's purview until the inspection?
That's not my understanding. I have not heard that yet.
I think I kind of heard that.
I
That
haven't
no
heard
one
that.
else can see it until the determination of the
I
inspection.
have not heard that yet.
Can we have that as a question for Erin?
You can ask her.
Okay.
Yeah, that's fine. And I don't mean to be rude.
Nobody else has
no,
heard that
I
about-
want you to ask her questions, right? I don't want, ask her whatever questions you have, please.
But the reason I bring it up is because of the question about the inspection that you mentioned.
Mm-hmm.
And if the apartment does not pass, then my understanding with that is that it can go to anyone else. It's open to anyone else. It does not have to bounce back to someone
Correct.
on a
If you have
program.
another otherwise qualified tenant, yes, that's what I said, yeah.
Okay, thank you.
Donna Breen, Chautauqua, Cattaraugus County. Where you were talking about utilities and not allowed to do a credit check to see if they can afford to pay for those, where we live, unpaid utilities become a lien on the property. Does that allow us to do a credit check for that?
No. No credit check means no credit check. No exceptions.
Anthony,
Where are you?
I'm here.
Okay.
As to pets, I'm under the impression that, as I know, the insurance companies will not grant you homeowners insurance if you have a pit bull. Are we allowed to refuse if there are pit bulls?
If they're service animals, no.
If they're what?
If they're regular pets, yes.
Right, I understand that, but if they're not service animals?
Sure.
Andy Caccialo, Greater Rochester. Thank you, Andy. Does this law address foreclosure, holdover, evictions, or are those folks who remain in a house after the bank owns it afforded any tenant rights more than, you know what I'm saying?
Yeah, I have not looked into that. That's outside the scope of licensure. I like using that.
Okay. I have a question. Can
Yep.
a landlord ask for references?
A landlord may ask for references.
Mm-hmm.
Nothing prohibiting them asking for references.
Okay.
Anthony Christina from the Bronx, Manhattan Board of Realtors. I have a concern. How does a landlord decide or determines who they take? They have a working person, you cannot based on credit anymore. You have a program, Section 8. And how do they decide who they take based on what?
I don't know. That's up to the landlord. Listen, there's very little guidance I can provide you. And I don't like saying that, believe me, but there's very little guidance we can provide.
Hi. You touched on this before. Are they allowed to collect more than 1 month's rent up front, like in seasonal? Sometimes we take the full.
At this point, I'm going to say no, because we don't know, but the answer is no until there's some clarification on that.
Okay.
Seasonal, college, right? Some kids pay for their place in the whole semester.
Correct.
We don't know if that's permitted. If you read the law very strictly, then they cannot do that. But we don't know yet. And I believe there's a member of the legislature from Long Island who's introducing legislation to permit those seasonal types of rentals. I read that already. So there are bills out there that haven't gone through the legislature yet because they're not in session that will be clarifying these, and that's going to happen somewhere down the line.
The question is a mobile home park where you own the residence, but you don't, but you lease the land. How does this law affect that particular incident when it's a land lease and eviction?
I believe that it does say it is applicable to mobile homes as well for rentals. A lease is a lease is a lease. I believe that's what they're referring to. So, yeah, it's applicable as well. Okay.
Hey, Anthony.
Up more. All right.
Michael from Long Island.
Yep.
Going back to the credit report and the Section 8 paying all the monies of the full rent. If you look at any of the situations where we talk about credit reports, we really don't run credit reports from the landlord's perspective. We run background checks. And the background check just happens to include a credit report, but the background check will do judgments, liens.
Yeah, no, I'm familiar with them, yeah.
Okay, so the situation comes down to, if you say I can't run that credit report because they're paying the full boat, well, I still want a full background check which runs the credit, and I want to know, was there a landlord deficiency in there? Are they rapists? You know, who do they, so on and so forth. You got the idea. So can we separate that?
I don't believe that you can.
I don't like your answers.
Yeah, no one does.
Christine DeGrandi Jones from Dutchess
Last question on this topic
Association.
too, folks. Last question on this topic.
Christine DeGrandi Jones from Dutchess. Is it true that you cannot, you may not ask for a pet deposit?
We don't know. Okay, next topic. I don't know. I don't know. I don't know. All right, next topic. Another decision of interest. New York State Office of Administrative Trials and Hearings, May of 2019. In 2013, tenant began transitioning from a male to a female. The landlord gave her weird looks when they met in person. They were fine on the phone, by the way, but when they met in person, they gave them weird looks. In November 2015, landlord told the tenant that they would not renew her lease, which expired in October. So they went to look for an apartment. They got the lease. Then the landlord decided they would not renew the lease. Tenant was told by acquaintance that they had apartments available. Tenant made numerous calls to the landlord. Tenant left a message under the name Gregory, which was the name they were using at that time prior to the transitioning occurring. Landlord told the tenant they had a couple of apartments available, and they told the tenant to meet them at the office to discuss the leases. Upon arrival, the landlord looked shocked and surprised when Gregory walked in the room. The landlord said, "Why didn't you tell me you were transgender? Thank God I had you come here at night. What would people have thought if they had seen you?" Now, we can just stop right here. Right? Unfortunately, we're going to keep going. The fact that the tenant was transgendered, the landlord said, changed everything. Could not rent her an apartment around people and children. I don't know how, aren't children people too, right? Kids are... we'll find you an apartment in a basement somewhere with its own entrance and not around too many people. Like a leper colony almost, right? And then, I hate to tell you, they made other sexually inappropriate comments, which I can't even allude to, they were so offensive. Literally turned my stomach. And things don't really turn my stomach, just so you know. But yeah, this was just disgusting. Despite the landlord saying he could put the tenant in a basement apartment, they never returned the tenant's calls. Tenant later found housing through welfare benefits. The tenant claims they felt sad at the landlord's comments and behavior. The comments were devastating to her life. Her sense of independence was shattered, and she felt powerless after meeting with the landlord. The tenant spoke with her therapist and friends and co-workers about the situation. Her co-workers have stated that the tenant was more withdrawn and more introverted after this occurrence happened. And they encouraged her, and she did file an action with the New York City Human Rights, and the landlord never showed up at the hearing. Right, that usually tells you something, right? So they were found in violation of New York City Code, and they discriminated against the tenant because of gender identity, and the landlord was found guilty, a $10,000 civil penalty, a $15,000 fee for mental anguish, and all the staff must attend anti-discrimination training. Now, I brought this up because it is a case involving New York City and New York City law. But this year, New York State included gender identity as one of those protected classes again. So if this were to occur anywhere in New York State now, it would be a violation and it would be discriminatory conduct on behalf of the landlord. Okay? But I mean, I figured people would maybe stop saying those kinds of things, but I guess not. So I thought it was an interesting case. So, if you read the real estate rags, dual agency is under fire across the entire country and in other countries. Dual agency is the redheaded stepchild. And every time something happens negatively with dual agency, it makes dual agency weaker and weaker and weaker as far as something that we can properly practice. So let's talk about best practices concerning dual and designated agency and what licensees should be doing to avoid potential liability. So I categorize dual agency into two types. There's single, where the same agent represents both sides of the transaction. And then there's dual, where one licensee represents the seller, one represents the buyer, but they're both under the same brokerage. So in my opinion, there are two different types of dual agency. Single dual agency receives the most criticism. Why? Because consumers, attorneys, and judges don't believe that a licensee can be unbiased representing both sides of a transaction. And for those unscrupulous licensees, this is the opportunity for them to act in their best interest over that of the seller and buyer. Okay? Now, there's nothing wrong with single dual agency, but it is the more problematic of the two. As long as you do it correctly, there's nothing wrong with it. But it's when licensees don't do it correctly, because they want to get both sides of the transaction for themselves, that it becomes problematic to us. Dual is less problematic. I'm going to refer to it as dual, right? I don't know why, but I figured that'll stick in your head a little bit more than giving it some other kind of name. NYSAR, right? Our association supports the proper use of dual and designated agency, right? We've advocated for the passage of legislation to make it simpler. NYSAR has provided educational materials through the forms of my presentations, articles, forms that we provide to all of our members. NYSAR is unaware of any push to eliminate dual and designated agency in New York State at this time. There may be factions of individuals who don't like it, but we're unaware of any legislative push to take it off the books. So here's some questions we need to ask ourselves. Is merely presenting the agency disclosure form enough to show informed consent? How many people think that just giving the disclosure form is enough for informed consent? Raise your hand. I love all of you. Thank you. You really listen to me, right? Just the form is not enough. It's just a form memorializing a conversation you have with the consumer about agency. What are they giving up? What are they not giving up? What are they getting, right? You have those conversations. Do you think a buyer, seller, landlord, or tenant understands dual designated just from the information provided on the agency disclosure form? No. Neither do you. Right? No, I mean, it's very... Sorry, it's one paragraph, right? It should be 2 pages, not one paragraph. However, the view of the legislature is different than what our members believe to be true. When we were negotiating with the legislature for advance informed consent to dual and designated, we found out what the legislature's belief was, or at least certain members of the legislature. Initially, it was called the advanced consent to dual agency. The legislature made us include the word informed. Informed means more than just the form, okay? They made us include that. I think that's important to take note of, all right? If you have the legislature saying, we like your bill, but we want to add this one word, just one word, it's usually a pretty important word, right? It's not like the or and, it's you know, informed in this case. So when the bill was first passed, we negotiated out, they said they need informed consent. Just putting the form in front of them isn't going to work. And we agreed, because that's what we've always been teaching our members. Informed consent is a required component of the agency disclosure form. And again, informed consent is not achieved just by giving them the form. There was a court decision this year addressing dual and designated agency, where the court said an agent acting as a dual agent must explain carefully to both the buyer and seller that the agent is acting for the other party as well. The agent should also explain the possible effects of dual representation, including that by consenting to dual agency, the buyer and seller are giving up undivided loyalty. That's the very least you should do. This is right out of a court case. How do you comply? Well, NYSAR has drafted 2 forms for our members to use. One is called Advance Informed Consent to Dual Agency. One is called Advance Informed Consent to Dual Agency with Designated Sales Agents. They're about 2 or 3 pages each. They are available in the NYSAR statewide forms library, which is available through Zip Forms Plus, which you all get a free membership to as a member of NAR. So if you have not registered for Zip Forms Plus yet, you can do so for free. And then it will automatically populate your statewide library based on your NERDS number, and these forms are in there. If you want to take those forms yourself, use them for your local board, you want to make them for your brokerage, give me a call. I'll give you a Word version of it, and you can put your own logo on the top. I don't care what it says on top. I care that you use them. I want you to use them. I sent them to the Department of State and said, what do you think about these? Do these meet informed consent? The answer was yes. Both forms meet the DOS's interpretation of what informed consent should be. That's enough to protect all of you, okay? It explains the pros and cons of dual and designated, tells you what you can do, what you can't do. I recommend you review the forms as well to refresh your recollection, right? I mean, just from doing things over and over again, we sometimes forget the exceptions or nuances. It doesn't hurt to refresh your recollection. I do it all the time. I go back and reread the real property law on a regular basis to make sure that that one sentence I don't use all the time, that I'm not missing it, okay? Again, statewide forms library through Zip Forms. You get a free account with NAR membership. I also want to announce that the NYSAR statewide purchase contract is also available on Zip Forms now. That was put up last month. There are 3 different versions of the statewide purchase contract. Traditional size, large font, and then home equity theft prevention compliant. So there's 3 different versions of that contract if you choose to use them. Again, best practice for every dual or designated scenario, have them sign the NYSAR forms in addition to the agency disclosure form, okay? Provide a copy of the form to the consumer and then put a signed copy in your folder. Again, in the dual situation, I say designated agency would be the best practice if the 2 parties consent to it, because that way there you're advocating for each of those individuals rather than acting kind of like neutrally as a dual agent. So if there's more than one agent involved, I would push for designated as long as the buyer and seller consent or landlord and tenant consent to it. Now, what's the future of dual agency? Well, there are movements now to abolish dual agency. British Columbia took it off the books. It is illegal to practice dual agency in British Columbia. I know, I'm not going to BC, it's okay. Again, I mentioned single agents more problematic. If you're doing dual agency and you're a single agent doing it, be very careful. Right? Use those forms that NYSAR provided to you. Right? Don't show or don't act in one client's interest to the detriment of the other. Right? You are Switzerland. You need to be neutral. Okay? Again, there's no legislative push in New York to abolish dual agency at this time. And again, NYSAR still supports dual agency until our members tell us to do something otherwise. Any questions on dual and designated?
The NYSAR form should be only provided when there's a instance of dual agency or along with the New York State disclosure?
The NYSAR forms should be utilized when the buyer and or seller agree to advanced informed consent to dual or designated, or dual and designated occur transactionally if they didn't agree ahead of time.
So just not at the first, not
Well-
using the disclosure.
Well, if on the disclosure
explain
form,
the
if they
disclosure.
consented to advance informed consent to dual or designated, you'd give them that form so they understand what they agreed to in advance.
Okay, thank you.
Okay? Advance informed consent to dual, advance informed consent to designated. We try to keep it simple. Yeah, go ahead.
Because of the informed consent requirement, should any agency form be pre-checked before discussion with a client or customer?
I would not pre-check any agency form.
Can you say that again for everyone?
I would not pre-check any agency form. Now, you can have a stack of agency forms pre-checked, a seller agent stack, a buyer agent stack, a dual agency stack, just so you don't have to use your pen, but you shouldn't have one form filled out anticipating all consumers will agree to that type of agency. Yes.
Yes, my question has to do with the designated agency you mentioned. You prefer to do that? I'm going back a few years, but with the designated agency, isn't it true that you as the principal broker would assign Joe to be a seller's agent and Sue to be the buyer's agent within the same listing in the office?
Yes, a principal broker cannot be a designated agent.
Right. Now, at the end of the day, that case goes to court. That principal broker is now split in half. Who does he represent as the dual agent, because he is now the dual agent?
The principal broker is a dual agent.
Right, so who does he represent if there's a case between the designated buyer, designated seller agent? Within your own company,
The broker represents both parties.
as a dual agent?
Yeah.
Okay.
Unless the broker knows one of their licensees was wrong in what they did, then they can obviously go against them. But if it's something that was brought to litigation, the broker's eyes, both parties, both of their licensees acted pursuant to the law, the broker's not going to support one over the other.
Okay,
Okay?
thank you.
Hi, Anthony. If I end up on both ends of the transaction, am I allowed to change my agency to non-agency and just become a transaction broker?
I never heard of transactional brokerage. I cannot comment on transactional brokerage.
Yeah, hi, Anthony. Common practice, a lot of companies say you can't be a dual agent, so if you have two clients as a single agent, they're going to say you need to give one of those clients up to another agent in the company, practicing designated agency. But they don't give up the commission. They give up maybe a small portion of the commission, say, you know, can you take my client so I can practice designated agency, and here's $1,000, $2,000, and I'm still gonna have a big interest in that transaction. To me, that seems like a fake, faux dual agency relationship, because you can, they're on paper, they're saying, okay, one is an agent for the seller, one is an agent for the buyer, but one agent could pretty much collect all the money except for a small referral fee just to pass that agent over. So it looks like they're doing a dual agency. What is your feeling on that?
Commission has no impact on agency. Who collects money has nothing to do with agency. So long as they're acting as dual agents properly, I don't care who gets paid.
Okay.
Yeah, payment has nothing to do with it. Anybody? Bueller? No? Okay. Next up, another decision of interest. City Court of New York, Mount Vernon, from last month. Landlord files for eviction based on a holdover. This is a great case, by the way. This case just came up last week, so it was very, very new. So if I stumble through it, it's just because I haven't completed the memory yet, but I hope I can get through it. Landlord files for eviction because the tenant's holding over. Landlord claims the tenant violated their pet policy in the lease and failed to cure the breach. So there was a breach, landlord notified the tenant of the breach, tenant did not remedy that breach in the requisite time, and the landlord filed for eviction. The tenant claims the pet is an emotional support animal, right? Remember the case we had out of Connecticut that was similar to this, where the dog was there for the grieving process, right? So this is what's happening here. Different case, though. The no pet clause reads that dogs shall not be kept or harbored in the apartment unless in each instance it be expressly permitted in writing by the owner. That's pretty clear, right? You want a dog? Ask me. I'll give it to you in writing. If I say no, I say no. The landlord was advised in February and March that the tenant had a dog. The landlord conducted an investigation and found out that the tenant did in fact have a dog. They witnessed the tenant walking the dog in and out of the apartment, outside to go to the bathroom, and back in again. However, the tenant never notified the landlord about the emotional support animal. So the landlord had no knowledge but for what they found out themselves. Okay, everybody following? Okay, it gets really good. The tenant admitted to bringing the dog in without permission of the landlord. Tenant claims he suffers from kidney problems and depression. I'm trying to figure out how the dog helps with the kidney problems. You know, things that make you go, right? The tenant claims the conditions permit him to keep the dog as an emotional support animal, which may in fact be true. The tenant claims their therapist recommended that he get an emotional support animal, right? We're getting closer to him being someone who's qualified to have an emotional support animal, right? The therapist is involved. They said he should get one. We're going down the right path to get this done the right way. So the tenant obtained the dog in February of 2019. They registered the dog with the U.S. Service Animal Registry. The tenant received a certificate and photo ID for his dog as an emotional support animal. This is the website that he used, usserviceanimals.org. It's an org. It's got to be official, right? It's not a com, it's an org. So, if you register your dog with U.S. Service Animals, you get a ID card and a certificate of registration, right? That's my emotional support Taco Bell dog, right? No, my nephew has two. I love them. They're great dogs, but they shake a lot, you know? It's weird. I don't know. So, the court said this registration may be sufficient when presented. Oh, no, sorry. The website for usserviceanimals.org states that this registration may be sufficient when presented to individuals in your everyday life. The ID card, in addition to a vest, collar tag, and leash, many times go unquestioned. Doesn't that seem deceitful just in the way that they presented it? However, in order to receive federal legal protection for you and your dog, federal law requires that you present your prescription letter for an emotional support animal to your landlord. If you need a letter, click here and their doctor will give you one. If approved, you receive your letter the same day. And then you'll be protected under the Fair Housing Act because you have the letter, right? Service animal, letter from a mental or medical health care professional stating you have a disability and the dog alleviates some of those signs or symptoms because of that disability. That's all you need. So all they need is a letter. Not from a doctor, it can be from a social worker, their therapist. The bar is very, very, very low. And you can get them online, right? Again, they talk about all the different things. Click here again. All for only $79.99. Right? These are cut and pasted off their website. After that paragraph was all for only $79.99. So to establish a violation of human rights law, you must show that the person has a disability, the accommodation is necessary, and the building owner has to refuse to make such an accommodation. The tenant failed to submit any evidence that the dog helped him with any of his symptoms of depression and/or kidney disease, and he failed to present any medical or psychological evidence to demonstrate that the dog was actually necessary in order for him to enjoy the apartment. All the tenant did was say that my therapist told me I should have one. Never called the therapist in, never asked the therapist to provide any kind of affidavit, anything to support their assertion other than them verbally saying my therapist told me to get a therapy dog, an ESA. The court only had the testimony of the tenant and his documentary evidence registering his dog as an emotional support animal with an internet company, USA Service Dog registration to rely on. I like how the judge mentioned an internet company, right? You're kind of guessing where the judge is going to go with this one. And it's in red. It should be noted that the registration of a dog with this entity can be completed by anyone after paying a fee, and there is no case law or statute requiring this court to accept this entity's determination that a dog is deemed to be an emotional support animal. Right? Now we know if they give you that certificate or the tag or they show you their dog's vest, I don't care. What do I want? A letter from your medical or mental health care professional stating your disability and the requirement for the dog as an accommodation. Pardon me? Come see me after the fact, Barbara. We don't disclose case names because sometimes they involve our members. That's why I don't give you citations here. Okay? Ooh, upcoming proposed changes. This sounds exciting.
Question.
Yeah. Oh, we have questions? Sorry. Where question? Where? Oh.
Hi, Linda. Hi, Linda D'Amico from Long Island Board of Realtors. I was under the impression that you have to have the letter from your doctor or whoever, but you don't have to say what the ailment is for. That's supposed to be protected under the HIPAA laws.
Dear landlord, Anthony Gatto has a disability. He needs his dog in order to alleviate some of the symptoms of that disability.
Correct.
Signed, his therapist.
Correct.
That's all.
Okay, so it doesn't have to say,
No, nor can the landlord
we're going
inquire.
nuts. Okay, thank you.
Okay. Again, upcoming proposed changes to laws and regulations. So, the legislature passed a NYSAR-sponsored bill to add additional hours. Well, you still have 22 and a half hours for CE every 2 years. But within that 22 and a half, we're trying to add more core educational materials. So currently, of that 22 and a half, 3 hours are fair housing, 1 hour is agency. Unless you're a new agent, then it's 2 hours. NYSAR's bill said we're going to add onto those core requirements 2.5 hours of ethical business practices. Now, why are we doing this? Because you can take your NAR required 2.5 hours and have it count toward your CE with New York State, right? So that's a good one. And I think we all know that some licensees may need to be educated about ethical business practices from time to time. So we thought it was a required component. And a 1 hour requirement for legal updates. And I was surprised that this didn't come around sooner, only because of all the changes in laws, rules, regulations, and there's really no way to communicate this to licensees on a regular basis other than you paying attention to what NYSAR puts out. But the department as a whole didn't really have a mechanism in place for you to know what the new laws are. This will allow that to happen. So this particular session in the future, if this law gets passed, will count toward that 1 hour. Okay? Now, I mentioned that the legislature passed it, but it has yet to be called up by the governor. So it is not law yet, just to let you know. The other thing the bill does, it eliminates the grandfathering exception. So nobody in the state, thank you. So nobody in the state, regardless of how long you have been a broker, okay? I don't care if you sold the stable to Joseph and Mary. All right. When this bill gets passed, you need to take CE. Now, Changes would not go into effect until July 1st, 2021. So there's a 2-year period in time that those individuals who haven't taken them yet will be able to take it and get their 22 and a half hours of CE done. The bill was proposed and supported by NYSAR, came out of our Ed Management Committee, also came out of 12A. We had 2 different committees who agreed on this. So it's not something that was just like a fluke. There was a big support behind it as far as our membership is concerned. The other thing about this too, with the 22 and a half hours of CE, you would have, again, 7.5 hours of core materials to take, and then you'd have the other 15 as electives. So we still left enough hours in for electives whereby if you were a specialist or you have an area you specialize in, you can go and take those particular courses to again, improve your business practice in those areas, again, and taking the core courses as well, which we feel is very important.
Thank you. So it's going to go into effect July 1st, 2021, but everybody's licenses have different expiration dates. So what happens if somebody's license is coming up for renewal in August? Is there...
They would have to take those courses.
So they would have 1 month to take the 2020?
Well, no, they would know, obviously, ahead of time that they have to take that before
So
the
it would be
license
passed
renewal.
by July?
Yeah, which is why we gave it 2 years so that everyone could know when your license expires after July 1st, 2021, you had 2 years of us sending you emails saying you've got to take CE now.
Great.
As well as the department will send a letter out to each and every licensee as they do when the laws change to let them know.
Great. Thank you.
Sure. Somebody had a question? No? No? Okay. The second proposed law or regulation, this is a regulation. We are amending the advertising regulations again. The issue, I guess what brought this to the surface is issues relating to Zillow and StreetEasy and confusion by consumers as to who the listing agent is versus who's an advertising buyer's agent on the site, and the lack of such disclosures prompted REBNY to send a letter to the Department of State a few years ago asking them to clarify what the requirements were as far as brokers advertising property that's not listed with them and disclosing the identity of the listing broker and what role the advertising broker is playing in the advertisement itself or the transaction. So we negotiated this for 2 years. NYSAR did our very best to limit the amount of exposure that our members would have based on the change to the regulation itself. We made every effort to make the regulation mirror your requirements under the IDX feed as far as what you're supposed to disclose. The department said that was not enough in their opinion. Now, currently these regulations have been approved by the State Board of Real Estate. They've been submitted to the governor's office for approval. Once the governor approves it, they will go into the state register and to be open for public comment for 45 days. After that public comment period is concerned, the Department of State will review whatever comments they received and determine whether or not those comments would cause them to change the regulation or just let it go through as it is. The department is behind this 100%. I don't see them changing the regulation as it's written, so I'm going to give you a heads up. I'm giving you a heads up so that if you need to change your website, if you don't change your website on a regular basis, or you don't change the manner in which your IDX feed is displayed on a regular basis, you'll have some time to do it before the regulation goes into effect. So let's talk about the regulation itself. The first change regards multi-property or search page results. So every page of a website, including any page that displays multiple properties or property search results, shall include information required by the rules and regulations. What does this mean? When you go to someone's IDX feed, you type in zip code 12211 and that multi-property grid shows up. That grid must be in compliance with the advertising regulations. And I'll tell you what the new requirements are. Furthermore, any real estate broker advertising another broker's property, okay, for us, this means the IDX feed. If you have an IDX feed on your website, you have to comply with the new rules. Such advertisements must clearly and conspicuously disclose the name of the exclusive listing broker immediately after one of the following phrases. and there are 7 of them. Just so you know, this will be available, the presentation will be available on NYSAR.com for you to download, so if you don't want to burn out your cloud for all your photos, you can wait and get a copy of it next week. But these are the different ones that the DOS had permitted. NYSAR added 3. We went through a lot of brokers' IDX feeds to see what language they were using to disclose the name of the listing broker. We added every one that we thought would be applicable. The DOS turned down 2 of our suggestions as not being descriptive enough. Courtesy of and provided by, they didn't like. But listing provided by, listing provided courtesy of, listing courtesy of are okay. But just courtesy of and provided by were not. So how is this applicable? It applies to IDX feeds, okay? All brokers and their associated licensees that utilize an IDX feed online must be in compliance. The use of any phrase to identify the listing broker, any other phrase than what they give you is prohibited. Clear and conspicuous means above the fold. So when I click on that property and the full page display comes up for it, the broker's identity with the required phraseology should be above the fold, and consumers should not have to scroll to find them. So all of you that have the broker's name at the bottom in 8-point font, you need to move it. You have a lot of time to do this, which is why I'm giving you kind of an advance warning now, okay? If you have to scroll to find the listing broker, it is neither clear nor is it conspicuous. Okay? I don't believe it would also meet the reasonable, readily apparent standard either if it's below the fold. And the use of a logo does not meet the requirement. So these are some of those popular logos people use to identify IDX feeds. These no longer meet the requirement. You may leave them in the listing, but you must also include that required phraseology and the name of the exclusive listing broker afterwards. But just saying this doesn't meet the standards anymore, and a lot of brokers use this. The second component of this has to do with paid advertisements, right? Zillow, StreetEasy, those are the 2 big ones we know about, all right? If a licensee pays a third party for advertising, and that advertisement appears on a page where someone else's listing is also displayed, right? Premier Agent, okay, let's just, we all know this, I'm just using that as an example because we all know what Premier Agent is. You must disclose that the advertisement is a paid advertisement using at a minimum the word advertisement immediately followed by the real estate broker, associate broker, or real estate salesperson's name. Just so you know, Zillow was involved in negotiating these regulations. They are on board and have the changes ready to go for their programs. So they did not oppose this. Initially they did, then realized they couldn't win, they joined in and tried to make it as least damaging as they could, but we were involved as well. So if you're paying for an advertisement, you have to include the fact that it's an advertisement followed by the name of the broker, associate broker, or salesperson. What does this mean for you? And I've said this for years. Licensees are responsible for knowing how their paid advertisements are being displayed. If you are paying someone for an advertisement, you better know how they're going to display that. If you don't know and they do it contrary to license law, you're the one in trouble, not the advertiser. Right? DOS cannot find Zillow. They can find the licensee who uses Zillow and has the information displayed improperly. And I'm not saying that they do that, but I'm using that as an example we use. But you're the one who's liable. So make sure you get a proof, right? I want to pay you this much money, but what's my proof look like? How's this going to be displayed? If it's not in compliance, you're the one who's going to be in trouble. So be careful. Regulatory timeline. I mentioned before that to publish in the state register. The Department of State had a meeting last week with the State Board of Real Estate. We were informed that the governor's office understands the urgency of this regulation, and they anticipated getting through the governor's office sooner rather than later. If you remember, the last time we put something through the governor's office, it took us 2 years before it came out. This is a much shorter timeline, we've been told. They understand the urgency of it. Once it's published, you have a 45-day comment period, and then they can initiate the law or the regulation. We negotiated with DOS for a 6-month grace period once the regulation becomes effective, so they will not be disciplining members for 6 months after the regulation becomes effective to give all of you a chance to go and change the way in which other brokers' listings are displayed on your website or on Facebook or whatever else you happen to utilize other brokers' listings. After the grace period, DOS can enforce the regulation. And based on our experience with DOS with their investigation into corporate titles, I think you'll see them more and more doing investigations on their own rather than being prompted by complaints from consumers. If they know that there's violations out there, they can make money off it. I think that would justify their business model of investigating themselves independently. We are unaware of any opposition to this regulation. Again, review display of your IDX feed. Nothing prevents you from making the changes now. If you make the changes now to comply with this regulation, you will be in compliance with whatever laws are in place now. And you won't have to worry about trying to change at the last minute when the regulation goes into effect. I need to warn you, not all paid advertising entities will be aware of the new regulation. Make sure if you have someone you use that they understand the new regulations coming so they can make those changes to the code before your advertisement is displayed improperly. Oh, real quick, last thing, I promise. There's been a change to the filing law as far as LLCs are concerned. Everybody know the TP 584? It's that 4-page document you file with tax and finance at closings. Now, in order to have more transparency in the process, if the purchaser or grantor is an LLC, you must make an attachment to TP 584 naming all of the individuals, including members, managers, or other authorized persons of the LLC. If the LLC is owned by another business entity, then you give the names of all those individuals who own that other business entity that owns the LLC. Until such time as you can show full transparency, listing the names of individuals who are members of that entity that is directly or indirectly purchasing the property. Again, the last line of the law, you keep disclosing until full disclosure of ultimate ownership by natural persons is achieved. So if the property is owned through a chain of LLCs, you work your way up to the top until you get someone you can identify or individuals you can identify. That's in effect today. It's in effect now. I believe it was the 13th it went into effect, Leah. So they have yet to amend the form, okay? If you've ever seen the form, it says individual, entity, a little checkbox. One will say LLC, and then they're going to add an addendum to it. You can put down the names of all the individuals. Until such time, whoever fills them out will just have to do their own addendum until the form has been updated, okay? But again, a lot of times you're not the ones who fill these TP 584s out, but I want to let you know in case you hear about it, so you don't sit there and scratch your head and say, I never heard about that before. I do not believe you have to get the information. Leave it up to the attorneys of the title company. They're the ones who do the TP 584. Okay? I'm done. Thank you for coming. Don't forget, if you want CE,
Excuse me.